Honorable Mr. Justice Panachandji Jain, the former judge of the Rajasthan High Court and the chairman of the Kanoria School of Law for Women. Honorable Mr. Justice N.K. Jain, former Chief Justice of Tamil Nadu and of Karnataka. Dr. Rashmi, the Director of Kanoria College. Dr. Arora, the Principal of the Kanoria School of Law for Women. Mr. T.C. Agrawal, the President of the Rajasthan Education Trust. Brother J.K. Ranka, Trustee of the Rajasthan Education Trust and a former judge of the Rajasthan High Court. Brother Bhavarlal Sharma, former judge of the Rajasthan High Court. The learned academic staff, the brilliant students of the college, the non-teaching staff, ladies and gentlemen. It is indeed a rare privilege and a great honor to be invited to deliver the third Justice S.C. Agrawal Memorial Lecture by the Rajasthan Education Trust and by the Kanoria School of Law for Women. At the outset, let me confess that I am slightly frightened of addressing this august house, for I have before me those elderly gentlemen judges before whom I have practiced and perhaps even demonstrated a lot of my ignorance about law. I almost feel like a priest who is asked to light a lamp in a temple before the very gods, who are nothing but the embodiment of light and enlightenment themselves. Who am I to show light to such erudite persons? And let me tell you, when I was appointed, a dear friend of mine, who then was known as Alok Sharma in the bar, but retired as a former judge of the Rajasthan High Court, he walked up to me and he said, "Oh God, do try to become half a decent judge on the bench." That's an advice and a request that has always stuck in my head. So today I'll try to be a half-decent speaker as well. But let me first thank both the Rajasthan Education Trust as well as the college for giving me a rarer opportunity, which I may never have in my life again, of delivering a lecture to my wife, Mrs. Rekha Chauhan. We preserve the memories of those who inspire us, who guide us, and who are our role model. Honorable Mr. Justice S.C. Agrawal Sahab. And I would never dare call him by his first name because he was too eminent and too respectful in my eyes and in my life. Is certainly one of those who continue to shine in our mental horizon. He was a judge with a stern face, and let me tell you that a smile of his could disarm the best of the lawyers of Rajasthan, if not of the Supreme Court. He was certainly a person with a very stern facade, but with the softest of the hearts. It's his boldness, his courage, his independence, his impartiality that has left an indelible mark on our memories. In his 20 years tenure as a judge, he authored many bold judgments and demonstrated his judicial and legal vision. But more than a judge, he was known for his human qualities. He was not only an avid reader, which all lawyers and judges should be, but was also a lover of music. An ardent follower of Swami Vivekananda, he followed Vivekananda's advice: arise, awake, and stop not till the goal is reached. He was a God-fearing person, and most of all, he was that rare breed of judge who could withstand pressure, who could boldly speak when the powers that be needed to be shown a mirror, something which unfortunately I wish we had more of Justice S.C. Agrawal Sahab in our judiciary today than we have. He continues to encourage us, to guide us, as all of us continue to explore the uncharted territories of our lives. We live in a new world order, a tectonic shift in our lifestyle, in our thinking, in our political, social, and economic arenas is no longer subtle. In fact, it can be quick, fast, and at times even brutal. Technology, if you remember, from the Industrial Revolution of 19th century, which has been written much about by the British authors like Charles Dickens, has always tended to upset our lifestyle and our thinking. Technology is like the boon asked by a king to Lord Shiva. And remember, Lord Shiva was always simple enough to grant a boon, but this boon soon will become the bane. It is a blessing and a curse, a transformative and disruptive force. It tends to facilitate many things that we would like to do, and today it tends to frighten all of us. In fact, the introduction of artificial intelligence is going to be our next biggest challenge as human beings that we will face. They are not only challenging our old paradigms, most importantly, they are beginning to open up a Pandora's box. And if you remember from Greek mythology, when Queen Pandora opened her box, what came out of it? Pestilence, sickness, evil spirits. Something that she could never put back into those boxes and shut them tight. In fact, technology is now beginning to challenge and raise so many constitutional issues that not only the Indian judiciary, but the judiciary all over the world will have to grapple with. And look at the present scenario. A YouTuber cracks an obscene joke in a comedy show, and FIRs are being registered against him. A sitting MP of Gujarat posts in social media a poem, and an FIR is registered against him. Both have to rush to the Honorable Supreme Court to seek and protect the liberties. Recently, in fact, the Delhi High Court had to lay down guidelines for students like all of you to be able to bring with you the smartphones. These are the fundamental constitutional issues that these technologies will raise before us, and we shall deal with them. If you remember, in the olden days, the best way to communicate was through letters and pamphlets, newspapers, and books. But those days are gone. Today, the social media has enabled instant communication. It has liberated our imagination and freed our speech. Communication, both verbal and written, has been democratized. The free flow of speech has turned what was known as the market of ideas into a carnival of offensive and hate speeches. Today, when we talk, we'll focus on two major areas, generally on social media, but in particular on hate speech, and then also see how the jurisdiction across the world, especially in the United States and India, deals with the very topic of hate speech. And lastly, we'll consider what are the constitutional issues that arise, and most importantly, what are the solutions that we may have in our future. As all of you may know, that social media began in 1997 with a platform called 6 Degrees. It permitted people to create profiles, connect with friends, and build networks. In 2002, you had the emergence of Friendstar, which expanded social network capabilities to enable its users to share content and connect through mutual friends. Early 2000s saw a rapid increase in social media, and today's statistics are slightly and certainly very impressive. You have YouTube with 3.9 billion monthly users, Facebook with 2.1 billion users, Instagram with 1.6 billion users, and WhatsApp with 1.1 billion monthly users. You also have controversial sites like TikTok with 954 million users. If you really look at it, social media is like looking at a beautiful red rose, fragrant, very enticing, and yet full of thorns. It is both beneficial and has its own disadvantages. Take the case for women, since I am addressing mostly in this house young ladies. Take your own case. It has certainly provided you with public space for voicing your concern, interest, and rights, and yet it has increased cyber stalking, cyberbullying. It has given you a false idea of what feminine beauty is, creating health issues for all of us. Take the case of students. It has given them access to information, to educational resources, networking opportunities, and for self-expression and activism. And yet, it has distracted them from their studies, led to poor academic performances, caused mental health issues, and social pressures. Similar is the case with sexual minorities. And even the judiciary is not left untouched by social media. It has given and introduced transparency by providing real-time updates on court proceedings, judgments, and legal developments. Ironically, it has also led to distortion of legal procedures and proceedings, if not to the trolling of a former Chief Justice of India. Thus, while it gives people a chance to see the way the judiciary works, with the increase in trial by media, it undermines the very concept of rule of law. While the people may be convinced that an offender is indeed guilty of murder, the judiciary may turn around and pronounce him to be innocent. People may wonder at the judge's impartiality and his motives. If social media has dark side, hate speech, on the other hand, is like the black hole. By tearing the social fabric, hate speech will eventually suck the vitalities of our society. And yet, ironically, to date, we do not even have a definition of the word hate speech which is accepted across the world. The most universal definition that we do have comes from the UN Strategy and Plan of Action on Hate Speech, and this is how it is defined. Hate speech means any kind of communication in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to religion, ethnicity, nationality, race, color, descent, gender, or other identity factors. The dissemination of hate speech will in fact frighten you. Between 2023 and 2024, India saw a phenomenal rise of hate speech by 74.4%. In total, there was a recording of 1,165 hate speeches across the country. And look at how they were shared in the social media. Facebook had 495 hate speeches available on its platform. YouTube had 211, and 266 hate speeches were shared in multiple platforms. Ironically, out of these, 256 hate speeches were against the Muslims. 111 called for economic boycott of the Muslim community. 274 called for destruction of Muslim homes and mosques. 123 asked Hindus to arm themselves against the Muslim minority. Surprisingly, even the Christians were not spared. 115 hate speeches were aimed exactly at the Christian community. And mind you, hate speech is not something which is unique to India. It is a phenomenon which is growing even in Western Europe and certainly continues to haunt America. And yet, look at the way the American Supreme Court and the Indian Supreme Court will deal with this common topic. Many of you may not know, the First Amendment to the American Constitution deals with the freedom of speech and expression, and it says, "The Congress shall make no law abridging the freedom of speech or of the press." At the outset, it may look like a limitless right. However, in two cases, namely in Johannes versus Illinois, Justice Frank Murphy had to limit this fundamental right by saying, "Speeches may be curtailed, including lewd and obscene, the profane and the libellous, the insulting or the fighting words for which by their very utterance inflict injury or tend to incite an imminent breach of peace." Justice William O. Douglas later on went on to say, The freedom of speech is protected against censorship or punishment unless shown likely to induce a clear and present danger of a serious substantive evil that arises far above civic inconvenience, annoyance, or unrest. Therefore, the American Supreme Court established two tests: a speech that leads to clear and present danger or to imminent to violence. Only that speech can be curtailed, none other. And I'll give you a burning example. There's a small suburb outside Chicago. In 1977, the Socialist National Party of United States wanted to take out a march through that suburb. And mind you, that suburb had a majority of black Americans and the Jewish population. And this was a Jewish population that had come to settle in Chicago, having escaped the horrors of the Holocaust. The Socialist Party decided that when they do carry out this march, they will not only carry the swastika, which was a symbol of Nazi Germany, but they will also burn the cross, which was a symbol of being anti-black. The municipal authority of that suburb thought, no, this will create a lot of animosity for the black community and the Jewish community on one hand, and the white supremacist, the Americans, on the other. Therefore, they banned the march. The National Socialist Party challenged that ban by the government. The county court upheld that ban. Even the Supreme Court of Illinois, which is equal to our High Court, upheld that ban. But when the case went to the Supreme Court said no. The government does not have the power to curtail freedom of speech and expression. Therefore, that march has to be allowed, even if it creates animosity between different communities. Now look at the Indian example. We had a very similar situation in the state of Karnataka. In the state of Karnataka, Dr. Praveen Bhai Thogoria, whom I don't know how many of you will remember, but in the olden days, he was one BJP leader who used to not only incite the crowd, but he would in fact distribute trishuls to the people. Now the question arose was that should he be permitted to enter the state of Karnataka to arouse and whip up emotions there. The state of Karnataka denied him the entrance to their state and to address public rally. The issue reached all the way to the Supreme Court in the case of the state of Karnataka versus Dr. Praveen Bhai Thogoria. And this is what the Honorable Supreme Court of India had to say, and I quote, "The valuable and cherished right of freedom of expression in speech may at times have to be subjected to reasonable subordination to social interests, needs, and necessities to preserve the very core of democratic life, preservation of public order and rule of law." It further went on to express its opinion by saying, and I quote, "It is imperative that if any individual or group of persons by their action of caustic and inflammatory speech are bent upon sowing seeds of mutual hatred, and their proposed activities are likely to create disharmony and disturb the equilibrium, sacrificing public peace and tranquility, strong action and more so preventive actions are essentially and vitally needed to be taken. Any speech or action which would result in ostracization of communal harmony would destroy all those high values which the Constitution aims at. Therefore, whenever the authorities concerned in charge of law and order find the person's speech or actions are likely to trigger communal antagonism and hatred, resulting in tendencies gaining a foothold, undermining and affecting communal harmony, prohibitory orders need necessarily to be passed to effectively avert such untowards happening. Therefore, the Honorable Supreme Court of India says no such speeches should be allowed in public domain at public places. Therefore, it upholds the very concept of reasonable restriction mentioned in Article 19(2) of our Constitution. In fact, if you look at the Indian laws, we have plethora of laws dealing with hate speeches. There are sections of the old IPC, now of course incorporated in the new criminal laws. We have even restrictions on hate speeches in the Representation of People's Act, in the UAPA Act, in Protection of Civil Rights Acts, and in other laws. In fact, the Information Technology Act is the main architecture of dealing with information technology in India. And look what it does. It empowers the government to direct and remove, block the access of any information, and it punishes the intermediaries. If you do not block or delete such contents, you are likely to be punished up to 7 years or with fine. However, at the same time, it imposes and gives and grants an immunity to intermediaries, saying if you follow certain conditions, you cannot be prosecuted in India. In 2009, we came up with a new set of rules called the Procedure in Information Technology, Procedure and Safeguards for Blocking for Access of Information to Public. In 2021, we have come up with the latest Intermediate Guidelines in Digital Media Ethics Code. They themselves impose certain obligations upon intermediaries to follow. It is not that we do not have strong laws, we do. The difficulty is that we have those who are meek when it comes to implementing the laws. And it is not just those persons who are saddled with the responsibility of implementing the laws. On 2 occasions, even the Honorable Supreme Court missed the bus. In the case of Zafar Imam Naqvi versus the Election Commission of India, a case decided as far back as almost a decade ago, in 2014, a direction was sought from the Apex Court to the Election Commission for disqualifying those political parties which engage in speeches stoking religious tensions. The Apex Court dismissed the said petition. Recently, a similar plea was raised in the case of Pravasi Bhalai Sangathan versus Union of India. Again, the Honorable Supreme Court, without even hearing the petition, dismissed it. The Law Commission, on the other hand, has opined in its 267th report that we must have a more nuanced definition of hate speech, a recommendation yet to be accepted by the government. Now, all these things, whether it is social media or hate speech, raise the following constitutional issues. What exactly is the extent of freedom of speech? Presently, the Honorable Supreme Court is tackling this issue in the case of Ranveer Allahabadiya. The question that arises in the case of Allahabadiya is, what is obscenity? Can a joke be obscene, even if it is distasteful? Even if it is vulgar, will it fall in the definition of obscenity? The question the Honorable Supreme Court would have to ask itself is, how do you define obscenity? In 2004, we gave up the old heckling test and we adopted Miller's test. Should we apply that to a joke? Does a speech become banned merely because it is offensive? And please remember what the Honorable Supreme Court had said in Shreyas Sehgal's case, that apply all your controls as narrowly as possible, because these words like offensive, vulgarity, obscene are difficult to define. The next question, who decides these limits? Should it be the government? According to the Ethics Code rules of 2021, the power was given to the government to decide whether a thing should be deleted or not, especially fake news vis-a-vis the government functioning. 3 months ago, the Bombay High Court has declared that particular provision unconstitutional. The matter is now before the Honorable Supreme Court. Then the question will arise is what would be the universal definition of the word hate speech? Who would check and who would control hate speech on our media? There are many suggestions that have come. For example, people have said that let there be now a digital literary program, not only for the students as told to us by the Delhi High Court, but most importantly for the people at large. Let the responsibility of educating the users be put on the intermediaries, on the government, and independent entities. More liability should be imposed on the intermediaries for not preventing or deleting harmful content. Other is to use more of AI tools so you can figure out when hate speech is being put on platforms and can be automatically by default be deleted. Recently, India has taken a very good step by instituting a National Creators Award 2024, which awards those who can create contents which deal with informative, educational, or community building contents. Ultimately, it is for you, the next generation, to decide as to what needs to be done. These are issues that will have both the sides of the coin, that will baffle you, will create a lot of dilemmas. These are issues that will ask all of us to have out-of-the-box thinking. But unless we think, we cannot progress. When we answer these questions, we must remember one fundamental principle of our history. And that fundamental principle is that for 5,000 years, our civilization is based on a foundation of assimilation, inclusion, and pluralism. Hate speech is what teaches us extermination, exclusion, and singularism. If we do not wish to rattle the very foundation of our civilization, it is high time that we try to control, crib, cabin, and confine not only hate speech, but also regulate our social media. I'm certainly thankful to the Rajasthan Education Trust and to the Kanoria College for giving me this rare opportunity of sharing my feeble thoughts on a burning topic. Thank you very much for your attention.